Okay, let's get right into this. So basically, here's the deal. There's the Office of Inspector General that released a report just recently about an unfortunate person who was kept in a basement in a body bag with fluids being poured on the body to go ahead and allow some other individual to continue to receive their check. This is not as uncommon as it should be. It should be very, very uncommon. But unfortunately, people who are retired and disabled ending up in bags or in a basement while other people collect their check is becoming something that is frightening and horrifying, and it is continuing. I need to go through this real quick. There's a case that was basically released. United States Court of Appeals for the 10th Circuit. This is Diana Martinez, petitioner appellant, Social Security Administration. We need to talk about how the SSA uses your financial information, bank account information, what you're spending, how you're spending it, debit cards, what money is coming in, what money is leaving. What basically has happened is that this case gives us insight into essentially the working product and design of the Office of Inspector General, which has what are called CDI units, which are like the secret police on behalf of the SSA that basically search for fraud. Now, I'm not saying searching for fraud is bad. I'm not even saying that with many of these instances that they shouldn't figure out what's going on with the banks. They should. They really should. But the thing is, to be very clear, I want you to understand exactly what they're doing here, because many of you don't realize what's going on. And to be fair, a lot of these other channels don't actually go into the nitty gritty. Now, normally I don't do full case, brief reviews because they're tough to go ahead and explain. There's a lot of terminology in there that people are not going to understand. I think this one we need to. I think this one is very important. This is an order and judgment. Let's go ahead and get into it for the circuit judges and how they ruled specifically on OIG. As part of an investigation into Deanna Martinez's eligibility for supplemental security income benefits. So Deanna Martinez was applying for SSI. The Social Security Administration Office of the Inspector General, the group that investigates people, oversees the secret police, the CDI units, served a subpoena, which is a demand request, right? It's where you send out a subpoena. You have to give me this. You have to give me that within so many days. On Miss Martinez's credit union, right? So they reached out with a subpoena for, financial documentation to her credit union to obtain the documentation to see what she was actually earning, what was going on. Okay. Miss Martinez filed a motion to quash the subpoena, okay, which the district court denied on February 12th, 2019. Okay, so basically they're trying, so one side is trying to get access. The other side is saying, I don't want you to have access. Don't touch it. Don't touch my credit union. That's what they're saying, okay? Ms. Martinez did not appeal, but nearly 3 months later, she filed a motion for the appointment of counsel, okay? And so this first claim that we're doing is just a really quick one that basically goes into essentially why you need to get an attorney if you're in this situation. So she filed a motion for appointment of counsel, but it was kind of late. Like they'd already kind of ruled on things. The district court denied the motion, stating that because it had closed the case, quote, there's no longer a need in this court for which appointment of counsel would be appropriate. Ms. Martinez appeals from the denial of her motion to appoint counsel. So the point of this case is to explain to you, number one, you need to act quickly with getting an attorney if they're trying to go after you. Because if they close the claim, then you're going to run into issues where you can't get one appointed if it's too far down the line, and then you have to go through an appeal process. SSA OIG argues that this court lacks jurisdiction over this appeal because it is moot. Under Article 3 of the Constitution, federal courts may adjudicate only actual, ongoing cases or controversies, right? Which is Lewis v. Bancorp. This, quote, this case or controversy requirement subsists through all stages of federal judicial proceedings, trial and appellate. Quote, when it becomes impossible for a court to grant effective relief, a live controversy ceases to exist and the case becomes moot. Putting it another way, she waited too long to get an attorney. They sought out her, bank records, her financial details, etc. And then as a result of that, it all kind of got bad for her, I guess is what I'm getting at. It all got really bad for her. Now, as a result of that, the district court resolved Mrs. Martinez's motion to quash the subpoena and close the case in February of 2019. Ms. Martinez did not appeal from that decision. Accordingly, as the district court recognized, by the time Ms. Martinez filed her motion for counsel, there was no longer any pending judicial case in which to appoint her counsel. Instead, any continuing controversy between Ms. Martinez and SSA OIG was and is only in the context of the administrative investigation, meaning the SSA then, at that point, did not have to deal with the legal claim that she filed against them. Okay. Instead, the SSA had open hunting season to go get those documents, review, and investigate her. To the extent that Ms. Martinez requests court-appointed counsel to assist her in that administrative proceeding, she does not cite any source of authority for either this court or the district court to take such action, and we are aware of none. Because there's no judicial proceeding in which to appoint counsel, and we cannot appoint counsel for Ms. Martinez in the administrative proceeding, we cannot grant her any effective relief. The appeal, therefore, is moot and is dismissed for lack of Article 3 jurisdiction. All right, so what do we learn in this case? We learn that when they're starting to investigate you, you have to go find an attorney almost immediately. Because if you don't, then when you file something to go ahead and, get them to not be able to access something of yours, if you wait too long, and a lot of people wait too long, this is way too common a thing, but if you wait too long, the court case will close. And then the only thing left open will be the administrative function case of the SSA, like where they're doing it inside the SSA, not through the legal court system, not through this court system. The only thing left open is the administrative adjudication, in which case at that point, then you've blown your, opportunity to go ahead and get counsel to stop them from accessing your information. Okay, that's this claim. So what did we learn? We learned from that one, go get counsel at least. And then after that, right, try and get the, attorney to go ahead and sign on and help you with that situation. Sometimes you can't get an attorney, in which case I do those private sessions. You'll see them in the bio where you can buy an hour and I'll walk you through what to do. Next case, Gordy Anamnachi, which is the movement, versus the Social Security Administration Office of Inspector General, United States District Court for the District Court of Columbia. Okay, now we're going through this case. In this case, memorandum, opinion, and order. Movement Gordy Anamnachi has filed a motion to quash an administrative subpoena issued by respondent, the U.S. Social Security Administration Office of Inspector General, for records of a bank account that Anamnachi asserts was maintained to facilitate the payment of Social Security benefits to an incapacitated person for whom he serves as guardian. Okay, so just to kind of clarify, there's a person receiving benefits. The person who filed this, motion to kind of not allow the SSA to access information that's financial information, he's the one that oversees the disabled person. He's the one who helps the disabled person. He is the guardian of the disabled person. He is very likely the payee of the disabled person. Okay. And Anamnachi proceeds pursuant to 12 U.S.C. 3410A, part of the Rights to Financial Privacy Act of 1978, which authorizes such challenges by customers of financial institutions. So what he's saying is the person overseeing the disabled person is saying, I do not want SSA OIG to get financial access to this disabled person's accounts. And he's saying, I'm going to file this suit to stop them from getting access to the financial accounts of this individual so that the financial institutions cannot hand over documentation about what's going on with the money. SSA OIG submitted a response pursuant to 12 U.S.C. For the reasons set forth below, the court finds that the statutory criteria for enforcement of the subpoena are plainly met here, as demonstrated by the sworn statements and other materials submitted by both SSA OIG and Anamnachi himself. The motion is therefore his motion requesting that the SSA shouldn't be allowed to access the payroll data, the bank data. That motion is therefore denied, and SSA OIG may enforce the subpoena. Remember, a subpoena is kind of like, think of it as like a HIPAA, but with more aggressiveness. A subpoena is a court demand, right, backed by a judge to go ahead and demand records from somebody, right? Could be a facility, could be a bank, could be a medical facility, whatever, right? A HIPAA is where a person just sends them, says, hey, okay, I have authority to go ahead and request records. A subpoena is where a judge demands the records for the purpose of an adjudication. Okay, so it's like a subpoena is like a more spicy version of a HIPAA. Okay. Background. The Right to Financial Privacy Act of 1978. Okay, so let's go through it real quick. 1976, the Supreme Court held that the Fourth Amendment does not afford bank customers an actionable privacy interest in financial records held by their bank. Okay, that was in 1976. Now, what happened was, okay, Congress responded in 1978 in passing the RFPA, which provides bank customers with certain rights when the federal government requests the records through the use of administrative subpoenas. So let's just solidify real quick. 1976, Supreme Court rules that you don't have full, complete rights to the privacy of your bank account records. Right? That pissed off Congress. Congress is like, and you can imagine why, because congressional members are like, I don't want the US government seeing what I've got coming. I don't want the US government seeing what I've got in my bank. Because, congressional members, as we're seeing now, it is very odd how somebody who's supposed to be making $250,000 a year seems to be making, $30 million a year. It is odd, right? We still have that problem today. But again, it is odd. All right. So in 1978, Congress passes the RFPA, which provides bank customers with certain rights when the federal government requests their records through the use of administrative subpoenas. Cool. Under the RFPA, such subpoenas may issue only if, here's the important part, only if there is reason to believe that the records sought are relevant to a legitimate law enforcement inquiry. Okay, so let me read that to you again so you realize how bullshitty it is. Okay, because it's like when you're sitting there, you're like, well, I don't think the SSA should have my records. The SSA turns around and says, well, we have a subpoena from a judge. And the only question is whether the issue is only if there is reason to believe that the records sought are relevant to a legitimate law enforcement inquiry. Pretty effing low standard for the government to meet, right? They could pretty much make that, pretty easily in most situations. Okay, so, the RFPA also requires that customers be notified of such subpoenas and afforded the opportunity to challenge them in federal district court. That's good, because otherwise you wouldn't even know when they grab your records. And in some cases, frankly, you don't know. You won't know. Okay, that happens a lot with phone records being purchased. Specifically, the statute provides that a customer may move to quash an administrative subpoena seeking her bank records within 10 days of service of the notice, or 14 days if it is mailed. Again, let me read that again. Specifically, the statute provides that a customer may move to quash an administrative subpoena seeking her bank records within 10 days of service of the notice, or 14 if mailed. So just to be clear, you got to move fast. If you don't want them to access your bank account records, within that 10 days, you got to act real fast. You got to hop on that pony, okay? If the district court finds that the motion complies with Section 3410A, it must order the government to respond and must decide the motion within 7 days of filing that response. So in other words, court's got to be quick. Court's got to zip, 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 make a quick decision. You get 7 days in and out, boop, boop, boop. The statute instructs the court to deny the motion and order the process enforced if, quote, the applicant is not the customer to whom the financial records sought pertain, or there is a demonstrable reason to believe that the law enforcement inquiry is legitimate and a reasonable belief that the records sought are relevant to that inquiry. Let me read it to you again, okay, so I can kind of explain what it means, okay? The statute instructs, okay? So the rules of, requesting these documents are, so the statute instructs the court to deny the motion, right? It's going to deny where you're requesting basically, hey, I don't want them to be able to get access to my bank account. Deny the motion and order the process enforced if, quote, the applicant is not the customer to whom the financial records sought pertain. Okay, so, bottom line is if there's a mix-up as to name or whatever, like this is the wrong person, you're really searching for these records. Or there is a demonstrable reason to believe that the law enforcement inquiry is legitimate and a reasonable belief that the records sought are relevant to that inquiry. So they're looking at essentially, okay, does this make sense? Is this related to the potential crime? Does it match up? Do the names match up, etc.? Okay. Next one. Conversely, under the statute, the court must grant the motion and order the process quashed if it finds that the applicant is the customer to whom the records sought pertain, and either that there's not a demonstrable reason to believe that the law enforcement inquiry is legitimate and reasonable belief that the records sought are relevant to that inquiry, that the government has not complied substantially with the procedural requirements of the RFPA. So what they're saying here is we got to go ahead and let them try and cancel the government's subpoena. If they can prove that they're trying to get the wrong person's stuff, or it doesn't really relate to, potential criminal fraud or criminal, situations where, you know, let's call it like it is. Sometimes the bank account records could be helpful to investigate a situation. But if they're not going to be helpful or they got the wrong person, then that particular, then that request is an overreach from the government. Because if the government's getting the records from the wrong person, then the government needs to be stopped. If the government is getting the records for something that's not going to equate to, an actual investigation for a crime, and we can't really connect the dots on this potential crime, then the government has to be stopped. But if the government has the right person, and the government has a situation where they're like, this we could find criminal, there's a possibility here. Possibility is pretty decent here. Then in that instance, they're allowed to continue. Okay. And then what you file to stop them would be stopped. Okay. All right. Next. All right. Let's look at this. The RFPA merely requires that there be a good reason to investigate. Okay. Which is, again, an extremely low standard. Okay. All right. So, as opposed to an illegitimate purpose, such as harassment or intimidation. So, in other words, like when they file this to request the documents, they have to have what is considered a good reason to investigate. Not a high standard, very easy to meet. They're not allowed to request the records if it's for an illegitimate purpose. So, if they're just trying to harass you or intimidate you or bug you or be like, oh, we got your nose. No. They have your financial records. They're not allowed to do that just to mess with you. They have to have a really true reason that you are committing some kind of crime. Okay. As courts have noted, this legal standard is far less demanding than the one governing warrants, which requires probable cause to believe that a crime has been committed and that evidence of the crime will be found in the place to be searched. So in other words, what I'm saying to you, what you should get from this is that the standard that the SSA OIG CDI units have, the secret police on behalf of the SSA, the standard that they use to go buy your bank records is so easy for them to meet. Like the little wall that they have to climb over, that they just basically put their pinky toe over to go ahead and buy your medical records, is super friggin' easy for them to do. They're gonna, in most situations, get access to your financial records because the standard is so very, very easy to get access, because they just don't require much of the SSA OIG to prove why they need the records. Now, traditionally, when you got to go and get a warrant, you need probable cause. Probable cause, I mean, you gotta have a claim built up. You got to be able to show the judge, hey, judge, da 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 da. And I understand the argument. Some judges are literally in place just to rubber stamp these things. I know that. I'm fully aware of that, especially when you get into firearms, stuff like that. I get it. I understand that. But the bottom line is this. Okay. The probable cause standard, let me read it to you again. Probable cause to believe that a crime has been committed and that the evidence of the crime will be found in the place to be searched. You got to know where, you got to know when, you got to know how, you got to know a lot of stuff. Right? But the SSA secret police standard, extremely low. You don't have to know that much. You just have to be like, we think maybe there's a little sniff over here. There's a little hunch over here. There's a little, you know what I mean? So just be aware. And that's one of the things I hope you get from this, is that the standard that they're using is a very, very low one. All right, let's keep reading so we understand the procedural aspects of this. Okay. On October 10th, 2017, SSA OIG issued an administrative subpoena requesting records from a financial institution related to an account for which Anam Nachi is a joint account holder. Okay. Because remember, he's the guy that's taking care of the disabled person. The subpoena seeks various account records, such as correspondence, transaction records, and account opening information dating from 2007 to 2017. So not a small period, a 10-year period, requested records to figure out how the money was spent, where it went, what happened. Okay. So SSA OIG provided Anam Nachi with notice of the subpoena, explaining that it was investigating possible fraud in connection with Social Security benefits. Okay, so they're looking for something that's fraudulent. They're looking for an abuse of funds. They're looking for the money not being spent the way it's supposed to. They're looking for a problem here. Okay, it could be fraud, could be similar fraud. On October 23rd, 2017, Anam Nachi filed the instant motion to quash the subpoena and attached an affidavit with exhibits. Okay. On November 2nd, 2017, the court ordered SSA OIG to respond. Okay, so in other words, the court said, all right, they responded. Now you got to respond. Ball's in your court, SSA. What are your thoughts? On November 20th, 2017, SSA OIG did so, attaching a declaration by Special Agent Eric Ryan. That's like a classic Amazon movie right there, with exhibits. All right, let's go into the analysis of this case to understand how they snoop on your financial records, okay? The court must deny Anamnachi's motion because in light of the submission of both parties, the record reflects, one, a demonstrable reason to believe that the SSA OIG's law enforcement inquiry is legitimate. So they have something that makes it look like there might be a crime actually going on. They don't have to have a lot of something, but they got to have an itty bitty amount of something that they can show to the court for the court to adjudicate this thing, to give the blessing, give the okay. And number two, a reasonable belief, not probable cause, reasonable belief that the records sought are relevant to that inquiry. And three, substantial compliance with the RFPA by SSA OIG. Okay, because remember how they get the records and what they do with the records thereafter, they are governed by the RFPA that Congress passed after the Supreme Court ruled that the government can, basically look at your financial records. So Congress said, no. You can look at our records, but you have to go through all these hoops and ladders before you can touch them. Sorry if I'm drinking a lot. I just I need this water because I have the coronavirus thingy. It's not the COVID that everybody has. It's a bug. It's a worse version, unfortunately. But I got, I work with the homeless and sometimes they give me presents. So, all right. SSA OIG asserts that it is investigating possible fraudulent activity in connection with Social Security benefits that were improperly paid to a deceased person. Get where this case is going? Let me read it to you again. SSA OIG, Social Security Administration, Office of Inspector General with their secret police, assert that an investigation, they're looking into it, with possible fraudulent activity, a crime was being committed potentially, in connection with Social Security benefits, the check that goes out, that were improperly paid, right? The check shouldn't have gone out to a deceased person because the recipient was dead. That's the kicker. The recipient wasn't alive anymore, okay? The investigation has focused on two Social Security recipients with the same first and last names, one of whom is alive, the living beneficiary, and the other deceased, the deceased beneficiary. Okay, so we got two people, same name. Two people, same name. The living beneficiary, born in 1938, currently receives disability benefits from the Social Security Administration through the District of Columbia Department of Disability Services, DDS, which serves as his payee. The deceased beneficiary was born in 1935 and passed away in 2003, but the Social Security Administration has nonetheless dispersed benefits for him since at least 2007. So we got our two people, same name. Okay, one was born in 1938 that's still alive. One's born in 1935 that passed away in 2003. And they've been still paying those benefits at least since 2007. Spicy, very spicy. Okay. All right, next page. The two beneficiaries are assigned separate Social Security numbers, right? Everybody gets their own social. SSA OIG asserts that in June 2007, 4 years after the deceased beneficiary's death, Anamnachi applied to serve as the representative payee for benefits for the deceased beneficiary. So in other words, you have somebody who passed away. That person who passed away then had a person named Anamnachi apply to be their payee. And as their payee, they were receiving the benefits on behalf of the person who had already died. So in other words, spicy, very spicy. Since then, SSA OIG claims those benefits have been paid into a bank account maintained by Anamnachi. SSA OIG further asserts that the subpoena at issue here is directed to that bank account and is part of a legitimate investigation into the circumstances under which Social Security benefits intended for the deceased beneficiary were improperly paid out. So in other words, just to solidify, right, the SSA is saying, hey, look. We think this dead person is receiving a check. And this Anamnachi is the one who receives the check on behalf of the dead person and therefore is committing fraud against the SSA. So in this instance, it's a good reason. It's a good reason to go and investigate this account, pull the information, find out if they're abusing the Social Security funds. It's like, that's what you guys draw from. You draw from Social Security funds. Okay. Anamnachi sets forth his own version of the facts, corroborating SSA OIG's assertion that he caused the deceased beneficiary's benefits to be paid into the account in question, but claiming that he did so unwittingly. He asserts that in 2005, he was appointed guardian of an incapacitated person he now understands is the living beneficiary. So basically, our payee is claiming that he thought the one he was receiving checks for was the living beneficiary with the same name, not the deceased one. Okay. Now, with that said, in the years that followed his appointment, he intended to apply for a birth certificate and Social Security card for the living beneficiary because he's trying to claim that he didn't know. He didn't know that the one that he was receiving benefits for had, in fact, passed away. In his telling, however, various government agencies committed errors that confused the identities of the living beneficiary and the deceased beneficiary during this process. As a result, the Social Security Administration reinstated benefits intended for the deceased beneficiary and paid them for almost 10 years into the bank account. And Anamnachi opened that bank account himself, and the funds were placed in there. Okay. However, once the error was discovered last year, he requested that the benefits be terminated. Okay. So Anamnachi requested himself that the benefits be terminated. On this record, there's obviously demonstrable reason to believe that SSA OIG is conducting a legitimate investigation into how the Social Security Administration came to improperly pay out these benefits. To be sure, Anamnachi asserts that he is blameless of any wrongdoing and that these circumstances are the result of innocent errors that caused a mix-up concerning the identities of the living beneficiary and the deceased beneficiary. He claims that he applied all the funds he received for the benefit of the living beneficiary as opposed to his own personal use, which, that's the way you're supposed to do it. And what we've got here is a mix-up where instead of giving the benefits that the living beneficiary was supposed to get, he was receiving the benefits for the deceased beneficiary. So, it's not like there was double dipping here. Like there was only one of these benefits so far in this case explained as being received, a name mix-up. And he didn't have the socials, so, you could see how something like that could happen, but let's keep reading. And he insists that he did not know the living beneficiary was already receiving other Social Security benefits through DDS, a separate payee. And bam! You have double dipping. I'll read it to you again. And he insists that he did not know the living beneficiary was already receiving other Social Security benefits through DDS, a separate payee. So what's happening here is the living one, that he's overseeing is getting benefits. And then he sought benefits for the same name. So now we got to look at this and say, okay, how fishy is this guy? How fishy is he milking the person who passed away? How fishy is this? Okay, let's keep going. All these claims may well turn out to be true, but they provide no basis for the court to quash the subpoena, for surely there's a good reason for SSA OIG to investigate the matter. Agree, makes sense. Right? We see there might be potential fraud here. There might not. You know what I mean? This could just be a mix-up. They could have screwed it up. They don't know how the system works. Happens quite often. Okay. As described above. Okay. SSA OIG asserts that after the deceased beneficiary's death, the Social Security Administration improperly paid benefits intended for him into the bank account targeted by the subpoena at issue. And Anamnachi, again, as already set forth above, concedes that he opened the account in which the Social Security Administration dispersed the deceased beneficiary's benefits for years, although he claims to have done so only in connection with his guardianship of the living beneficiary for whose sole benefits he directed those funds. So not a simple situation here. You got two people who come from the same era, 1930s. One of them passes away, one of them still alive. The one that's still alive still gets an SSA check. And then the one that's not alive, basically our hero submitted to be payee to go ahead and receive the benefits for the not alive one. But the two, disabled people, the two elderly people, they both have the same name. And if you don't have the social security numbers, maybe you could play that game. Maybe you could be in that situation. I don't know. Anamnachi further admits that it was determined that the funds were being improperly paid and that he requests that they be terminated. On this record, there's no doubt that the records of the bank account targeted by the subpoena are relevant to SSA's OIG's investigation. And Anamnachi argues that the bank records are not relevant to the investigation because the subpoena issued by SSA OIG incorrectly identifies the deceased beneficiary, as opposed to the living beneficiary as his joint account holder. The record is unclear regarding which of the beneficiaries is named on the account as Anamnachi's joint account holder. Ultimately, however, there is no discernible reason why this discrepancy, even if it exists, would nullify the demonstrated relevance of these bank records to SSA OIG's investigation, and Anamnachi offers none. So what they're saying is they're going to let the SSA get access to the bank account records, do a full search, do a full review, and figure out what's actually going on. That's what's going on here. Now, the RFPA provides that the government may obtain records by an administrative subpoena only if a copy of the subpoena or summons has been served upon the customer or mailed to his last known address or on or before the date on which the subpoena or summons was served on the financial institution, together with the following notice, which shall state with reasonable specificity the nature of the law enforcement inquiry. So, you got your basic request principles, who you have to notify, etc. All right, 12 U.S.C. 3405, subsection 2. To demonstrate substantial compliance, the government need not set forth the specific provisions of law that the customer may have violated or detail the evidence that spurred the investigation. Instead, all that matters, this is the important part right here, quote, all that matters is that the customer be given notice of the thrust of the government's investigation such that she had the opportunity to file a motion to quash. By the way, do you guys know what? Maybe you don't. Let me give you an exact definition here, because sometimes people don't know. Quash means to set aside or to void. In a legal context, quash can be used to describe the process of terminating proceedings or motions or describe the exclusion of evidence from trial. So in other words, think of it as like a squash, or think of it as like a wall, or think of it as like a dampening effect, like you're putting something over a candle to snuff it out, right? Cool. The subpoena and notice that SSA OIG provided to Anamnachi appeared on their face to comply with the RFPA. So it looks like the government sent in everything they needed to get the actual records, okay? Next, but Anamnachi once again contends the subpoena incorrectly identifies the deceased beneficiary as his joint account holder and asserts that his alleged error means the government has failed to comply with the statute. Once again, the discrepancy pressed by Anamnachi, even if real, does not support his claim. First, regardless of whether the subpoena properly identifies the other joint account holder, there's no question that SSA OIG gave Anamnachi notice that informed him of the nature of the investigation and identified the relevant account and the record sought. Undoubtedly, he received notice of the thrust of the government's investigation and opportunity to file a motion to quash because ... He did it, right? He responded. Like if he didn't respond, then we wouldn't know if he actually got the notification. Okay. Second, Anamnachi appears to argue that SSI OIG did not comply. So he's arguing they didn't comply with RFPA because the subpoena did not provide adequate notice to the other joint account holder, who he asserts is the living beneficiary. So he's saying, hey, look, you should have notified this other person because, this is all relevant to the investigation and the names are relevant, so you should have told him. The statute requires that notice be served on the customer of the financial institution. Moreover, each customer listed on the account must be notified that the government has requested access to his or her records. As previously noted, the record is unclear regarding which of the beneficiaries is named on the account as Anamnachi's joint account holder, but whichever beneficiary is so listed, the court concludes the SSA OIG substantially comply with the statute. So this claim is kind of tricky because the bank account isn't really sure who is the proper name person on the account. Is it the living one or is it the dead one? If it's the dead one, then they had to notify the only living available person, which was the payee, which they did. If it was the living one, then they should have sent a notification to the living beneficiary, right? And notified him. So, I can see the argument there. I can see the argument. Although to be fair, like they would just fix it. They would just submit another thing with their name on it. So it's not like this is really going anywhere for this Anamnochi guy. Assuming that Anamnochi is correct, the living beneficiary is in fact named as his joint account holder. SSA OIG accomplished substantial compliance, though service of the subpoena and the notice on Anamnochi himself. Oh, okay. Though service of the subpoena and notice on Anamnochi himself occurred, customers defined as any person or authorized representative of that person who used the financial service in question. So in other words, what they're saying is, okay, look. Maybe we didn't get the name right? But you're still, for the dead and the living, supposed to be the person that's like overseeing this. You're supposed to be the payee. You thought you were for this guy, and now it turns out to be this. You're still the overarching guardian of this situation. And customer can be either the actual owner of the account at the bank, or it can be your agent or your payee or your guardian. Okay. Next one. Therefore, the customer is notified so long as either the person who utilized the services or that person's representative is notified. In this case, Anamnochi states that he opened and operated the account in his capacity as guardian of the living beneficiary. While the RFPA does not define authorized representative, Anamnochi was acting as the living beneficiary's authorized representative under any reasonable understanding of that term. Okay. So, with that said, therefore, SSA OIG effectively notified the living beneficiary when it notified his guardian, Anamnochi. Alternatively, if the deceased beneficiary is listed as Anamnochi's joint account holder, the statute, reflecting common sense, does not require him to be notified because he's dead. You can't, what are you going to do? Nothing in the RFPA requires the government to notify a person who, though named on an account, died years before the account was opened. Such a person never utilized any service of a financial institution in connection with that account, and therefore is not a customer requiring notice because they weren't there when the account was open. All right. So what did you learn from this stuff? In the first briefed claim that we looked at, the district court claim, you have to act quickly to get an attorney, because if you wait months, they'll end your opportunity to respond and have an attorney and be able to stop them from accessing your benefits. So you have to get an attorney immediately. The second claim that we went through, we learned about the extremely low standard that the SSA has to step over, right? They got to step over that little wall to get access to your financial information. They don't have to use probable cause. They don't have to meet the requirements of probable cause to get a warrant. To basically get to subpoena your financial records, it's a much, much lower standard. The point that I'm getting at with this is that you need to understand that they have a low standard to access your financial records. They send out the subpoena, and then you get 10 days to respond, and then the court has to rule on it within 7 days. You have to understand that if the SSA is trying to get access to your bank accounts, if you want to stop them, if you have a problem with them accessing your information, you need to act quickly, because otherwise you will lose your right to stop their ability to access your bank account records. Now, some of you are not committing fraud. Hopefully most of you are not. Some of you are. So my point to you is, just be aware they're doing significant reviews of people's information right now. So you're going to be seeing, because of DOGE and Elon Musk, a lot of people having their bank accounts be searched. Now, when you're going through the basic process of it, you agree when applying for disability benefits on the form to give access, for your financial bank accounts to the SSA. And then within 30 seconds, they click a couple buttons and they can see your social security number and your bank account information and how it's all tied and where your money is. They can do the same thing with the DMV and seeing what cars you own. So the point is, to be very, very, direct and straightforward with this, is that you essentially need to be aware that they can very easily access your financial documentation. And you need to be very quick when you receive that notice that they intend to subpoena your financial records and respond to them. Okay. So All right. With that said, I hope you guys all had a good time going through this case and understanding how it works. Attorney Walter Hnot, the most viewed and subscribed to disability attorney in America. Please remember to like, please remember to subscribe. Head over to Google and type in Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there. That always makes me feel a little bit better. We got about 317 likes. Let's see if we can hit that like button. Also, I'm going to be going live directly after this video to answer questions for free. Also, very important. There is an option where you can hire me for a private session. Little mini contract is below. I'm going to grab some food and some more water real quick. I am fighting the coronavirus, but I will catch up with you shortly, and we will go ahead and rock and roll from there. Give me about 10, 15 minutes, and then I'll go live, and I will answer questions for free related to Social Security disability benefits or VA disability benefits if you want. That's fine too. I will catch you at the next video. Give me 10 to 15 minutes. We'll rock and roll from there. Thanks so much. Bye-bye, everybody. Bye-bye.